Hi everyone, my name is Johnny Roven. I'm a Los Angeles personal injury attorney, and today I'm going to be discussing with you the very exciting topic of giving your deposition. So what's a deposition? A deposition is a formal giving of testimony in an informal setting like a conference room. When you're at a deposition, you'll most likely have the other side's attorney asking you questions. You'll have a court reporter writing down everything that's being said. You'll be there. And if you're represented by an attorney, your attorney should be there. So a deposition is essentially a place where the other side is going to try and ask you questions pertaining to what you know about the accident, anything about your injuries, pre-existing injuries, how it's affecting your life. Those are the things that will be asked at a deposition. Before giving a deposition, you'll want to adequately prepare with your attorney. So you're going to want to go over the facts of the case, go over your injuries, go over how it's affecting your life. Anything that the other side is likely to ask you, you're going to want to try and cover with your own attorney so that you can be prepared to give the testimony over. The first tip that I have for you is to be honest. You want to just tell the truth. You don't want to exaggerate, so if something is not hurting so much, then you shouldn't say, oh yeah, it's hurting a lot. You don't want to exaggerate as to how the accident happened. Like you don't want to say that you got hit at 65 miles an hour when there's only a small dent in your vehicle. You just want to be completely honest in regard to everything. If you start lying and you start just giving a little bit more than the truth, then the other side is going to love it. The other side's attorney is just going to dig in and record that for later. Maybe they might not point to it out at the deposition, but they'll wait for the perfect time, like at trial, to say, well, isn't it true that you said the car was going 65 miles an hour, but if you look at this photo right here, does that look like a 65 mile an hour hit to you? These types of things happen all the time. It's very important to just stay strictly honest in your deposition. Even if you think that it hurts your case, it's better to be honest. Juries don't want to award liars. They want to award people that are telling the truth and that are truly owed the damages. The second tip I have for you is to wait a few seconds before answering a question. The reason for this is that it'll allow for your attorney to make proper objections. Like if they're going to object as to the question being vague, compound, lacks foundation, etc., you're going to want to have them insert those objections so that when it comes time to trial, the judge can rule on those objections and try and preserve your testimony. What happens is that a person may seem like giving a deposition is like a conversation, but it's really not a conversation. This is a place where your testimony gets written down, like grinded into stone, later to be used at trial. So you don't want to use this process like it's a normal conversation. You want to allow for your attorney to object. You want to allow for your attorney to tell you not to answer certain questions, and you want to allow for yourself to really think about the question that's being asked. So the best tip is to just wait a second or two before giving an answer. I know it might sound weird, but here, I'll just do an example. So how fast were you driving your car? 35 miles an hour. There's a little break in there, so the attorney can make their objection, etc. I've made my point. The third tip I have for you is to listen to your attorney. Very important to listen to your attorney. If your attorney is telling you you're talking too much, talk less. If your attorney is telling you don't answer the question, can you guess what I'm going to say? Don't answer the question. Let your attorney assert legal objections and tell you what to do, what not to do. Listen also to the objections that your attorney is giving. So, for example, if the attorney objects to the question being vague, ask yourself, is this question vague? Do I understand the question? Maybe I can have the other side rephrase the question so that it's a very clear question and answer. If the attorney objects to the question being compound, that means that there's really two questions being asked. So, ask yourself, are there two questions being asked? What question am I answering? For example, if the other side's attorney asks, were you on your way to work? Were you on your way to dinner? You don't want to answer yes or no to that question because there's really two questions being asked. So you can ask the attorney, can you please clarify what you're saying? I believe that's 2 questions. If you don't know the answer to a question, you can say these 3 magical words, and they're completely fine. They are, I don't know. That is a fine answer. The attorney might might pressure you to answer the question and say, no, you do know, you do know. I don't know. I don't know. That's a totally fine answer. But you don't want to overuse the I don't know, because that's just going to make you look like a liar. So, for example, if you say, if they ask you, well, what's your name? I don't know. Obviously, it's going to not look so good in the eyes of a jury or a judge. You know the answer to that question. Okay, so this is an important tip that I want to give you. So in everyday language, we say words like never and always. So in the law, the words never and always are not very good words because they're absolute words, meaning that never does not mean rarely and always does not mean most of the time. Never is never and always is always. So, for example, if they ask you a question, were you driving to work at 7 a.m.? And you answer, I always drive to work at 7 a.m. If they find a time where you were not driving to work at 7 a.m., they could say, well, didn't you say always? This is not good because it makes you not seem credible. And the most important thing in law is for a person to be credible and honest. Okay, so the next tip I have for you is to be aware of what's called the attorney-client privilege. So any communications that you have with your attorney is privileged. The other side does not have the allowance to know about that unless you tell them. But you should not tell them since you have that privilege. It's the attorney-client privilege. They don't need to know about your communications with your attorney. So if they say, well, what did you and your attorney discuss? Your attorney most likely will say, objection, attorney-client privilege, I instruct my client not to answer the question. And then you don't have to answer the question. Those are private communications between you and your attorney. The next tip I have for you is to stay calm. So the other side's attorney may try and ask you questions that might unnerve you, might make you a little bit upset, but you want to stay calm in that situation. It's very important that you not say something stupid at your deposition, like start insulting the other side's attorney or start insulting the person who you believe caused the accident. The other side's attorney may start inserting little jabs here and there or asking questions in ways that may seem unnerving. You want to just calmly answer the question. The testimony that you give can be repeated later. The questions that they're asking may or may not be repeated later. So it's important not to get rattled, not to get unnerved, not to call the other attorney names, not to call the other side names, because it's just going to make you look foolish and hurt the value of your case. The next tip I have for you is if you don't understand a question, think about it and say to the other side, I don't understand the question, can you please clarify? Very simple. You don't want to be answering questions that you don't really understand because those answers can be repeated back to you later on, and it's going to be difficult for you to tell a judge or jury, well, I didn't really understand the question when it was being asked. The other side might point out, well, so-and-so had the opportunity to say that they didn't understand the question, but they chose not to say anything. So is it true that they really understood the question or that they didn't understand the question? Perhaps in the beginning of the deposition, the other side's attorney may say to you, if I ask you a question and you answer it, can we all assume that you understood the question being asked? And you may just answer yes to this question, and later on down the line, all the questions that you are answering now can be repeated later and assumed that you actually did understand the question. So it's very important. If you follow the tip where you wait a second or two before answering the question, then you can listen to the question and see, okay, do I understand this question? All right, let's answer the question. It's also important because you don't want to get into a conversation where you and the attorney are speaking back and forth and getting into conversation mode, because a lot of testimony is going to get written down that may or may not hurt your case, and you're not giving your own attorney the opportunity to object. So hopefully your own attorney is saying, hey everyone, let's slow down. But if not, you should know for yourself, okay, I need to just give it a couple seconds each question. I know it may seem tedious, it may seem annoying, it may seem awkward, but you know what? This is not a regular conversation. This is your deposition, and this is an extremely important part of your case. Okay, the next tip that I have for you is probably very important throughout your entire case process, is to only answer the question that is being asked. This is perhaps one of the most important tips, but also one of the least followed tips. I see this all the time in deposition testimony. You only want to answer the question that's being asked. It's very difficult to do because it's so abnormal to everyday conversation, but it's so important in law. Okay? So, yes or no questions require yes, no, I don't know answers. That's it. When questions only require a date or a time. You want to say as little information as possible at the deposition in order to preserve your case. So you want to answer the questions completely, but you don't want to volunteer all the information that you have. You just want to stick to what the requirements are, and the requirements are only answering the question being asked. So if the other side says, well, when were you driving? You want to give a date and time. That's it. Just don't keep on volunteering information. Sometimes I'll go through deposition testimony and you'll see these pages and pages and pages of testimony just going on and on and on. And I mean, if I'm taking the deposition and I'm listening to the other side give their deposition testimony, if they want to keep on giving me all this information, I'm just sitting back, just listening to what they have to say. I mean, a lot of it could be helpful, and the attorney is just kind of sitting there listening. Okay, whatever, I'm just going to let my client say whatever, I don't really care. This ends up hurting their case down the line, which is great for me. I'm okay with it. I'm loving it. I'm just listening to what they have to say. But when it comes to my clients, I say only answer the question that's being asked. Who, what, when, where, why. Who only requires the names of people. What only requires what it is, so on and so forth. Okay, the next tip I have is not to get so bogged down with estimations. So the other side's attorney might ask you, how fast was the car going? Or how much time was there in between you seeing the car coming and the car hitting you? Or questions like, well, how far away were you from this location? If you know the answer to that, then you can give an estimation. But if you're not good at giving distances or speeds or those types of estimations, then just tell the other side's attorney that you're not very good at giving those types of estimations, so you'd rather refrain from giving those estimations. Okay, the last tip I have for you is when answering questions about your injuries, you should thoroughly discuss this topic with your attorney beforehand. So when it comes to medical diagnoses, you probably want to refer to medical documentation, but in regard to your pain and how it's affected your life, those are going to be easier questions for you to answer, and so you can go ahead and give those types of answers. You want to list every pain that you have, be completely clear. This is the place of your deposition where you should just give all the information. Tell the other side's attorney all the pain you're feeling, all the times you're feeling the pain, every single activity that it's affecting in your life, how you're feeling about it, your emotional distress. Are you sad? Are you depressed? Are you grieving because of how much pain you're in? You want to be very complete about giving those types of answers. I really hope you enjoyed this video. I'm looking for feedback, and I want to know what kind of videos you want to see. So leave a comment. Give me some suggestions as to what you want to see later on down the line. Give me a call anytime. My number is 888-7-JOHNNY-7, 888-7-JOHNNY-7. Have a great day. Thanks so much.